pressing for recognition within the Nigerian polity.
You know, I've been going through some of these and I realized another mistake we also made. We asked our last guest about the Naval Command, and as it is now, we understand that even the ships can't even fly that water except they get some kind of, should I say, permission from Cameroon. So it means that some of them are already holed up somewhere. They can't even come back home, so to speak.
Well, the Green Trade Agreement has some geopolitical implications. Precisely, the naval base in Calabar. Our vessels, warships can only leave or return to the base with the consent of Cameroon. So Cameroon holds a lane over the ingress and egress within the estuary of the peninsula. We had a conference in the NIA a few years back to discuss these matters with naval officers, and we brought this up. But the naval officers told us that Cameroon would not dare refuse Nigeria the right of entry or exit. But if push comes to shove and Cameroon says no, are we prepared to fight over the matter? Because right now, the naval base in Cameroon is essentially out of commission. More so after the judgment of the Supreme Court saying that Cross River State is no longer a littoral state, it's a landlocked state. So the implication, maybe the Supreme Court was looking at just the question of oil wells. Oil wells don't belong to Akwa Ibom. There's the revenue deriving therefrom, because the federal government that owns all these resources. But the shortchanging of Cross River State has implications for Nigeria's defense capability. So if the headquarters of the Eastern Naval Command is effectively decommissioned, then Nigeria should go back to review the geopolitical implications of that transfer. Because in law, the transfer of Bakassi does not happen. It's non-existent, because the Green Trade Agreement, which Obasanjo went to sign in New York with Paul Biya under the aegis of Kofi Annan and the permanent members, is yet to be approved by the National Assembly. A treaty that has not been subjected to National Assembly approval cannot enter into force. So the purported handover of the territory to Cameroon does not exist in law. So, and I am aware that the residents of Bakassi went to court and had an order, had an injunction forbidding that transfer. The National Assembly to pass the resolution. I remember Senator Henshaw and my very good buddy, my former student, the Senate leader, Ndoma Egba. They raised this issue in the Senate. Because Ndoma Egba, study international law. So he's aware of all these matters. And you cannot just force your way through. I don't know what the motive was for General Obasanjo. I had rumors of a prospective Nobel Prize or something. But in the event, no Nobel Prize was won. We lost the Bakassi, we lost money, and we had our face in the mud. So quite sincerely, the question of the strategic importance of the peninsula should not be lost on the Nigerian policymakers.
Okay, but Prof, so since Section 12, Subsection 1 of 1999 Constitution, which says, well, it has to be domesticated here first before they go ahead with it, they overlooked that part. It was raised at the time. Nobody said so much. I mean, the government seemed to have, they just glossed over it. Would it have been naive, or was it relevant, or would it be if Nigeria were to expect that the international community were supposed to ask, wait a minute, has this been rectified locally before you come forward? Did they assume that this was a non-issue?
No, it's not the business of the international community to ask Nigeria whether it are taking care of its domestic problems. Okay? What international law specifies is that you must implement a treaty entered into. How you implement it is a local affair.
As long as you're signatory.
It's your constitution that will tell you how to carry out. So what Nigeria, that's a case that it provides ground for Nigeria to say that handing over of the territory was a purported handover. In the eyes of the law, it never happened. So it's a matter which you can still press. Because really, I don't know what the hurry was to lower the Nigerian flag and hoist the Cameroonian flag and the Minister of Justice then was smiling. I mean, it was really a charade as far as I'm concerned.
We actually saw that on television, but again, you mentioned something. I wanted us to touch on that before we come back to this Bakassi issue. It's about the 76 oil wells.
Yeah.
And for some, they say, for now, we should feel so sorry for Cross River State because of that particular judgment. But I've been following your interviews, and you were trying to give some kind of precedence in a case between Ekiti State and Ondo State, and in court you say it was they called it Solomonic wisdom. Perhaps you should tell us more on that precedent, and let's see if that would have been very helpful in the Cross River Akwa Ibom State.
Well, the experience in Nigeria is that when new states are created, they try to share assets and liabilities. In the debacle between Ekiti and Ondo states, the Ondo state wanted to take it all. And the Supreme Court minced no words in saying that was utterly selfish. That you are parts of the same state. So the Supreme Court now declared a sharing formula of 60-40, which is equitable, so to speak. What I said in the interview you are referring to, I said it was Solomonic wisdom by the Supreme Court. You know what Solomon did about the women complaining about the children and all that. So the same principle could have been applied in the conflict, the case between Cross River State and Akwa Ibom State. But then that was not before the court. The court was to determine on whose territory those wells could be ascribed to be located. But the consequence of that judgment was that to all intents and purposes today, Cross River State is a landlocked state. You cannot share from any revenue in terms of the sharing formula for 13% and what have you. Don't forget also that the president, Ebele Jonathan, was worried 2 days ago about those who want to raise issues about the offshore, onshore, because he doesn't want to start a problem he can't finish. It's not his problem. But again, President Obasanjo, as he then was, sponsored that particular act to at least give some good feeling for Cross River State, especially after the offshore delimitation case which Bola Ige took to the Supreme Court, because that case determined that the boundary of littoral states was at the baseline from which the territorial sea is measured. So all the wells within our continental shelf, all the oil deposits within our continental shelf belong to the federal government.
Can we make any logic in this, saying that since the government actually didn't play its part well in the Cameroon, Bakassi, Nigeria matter, and now Cross River State is no longer a partaker in the 13% derivation, that the government should find a way, even though they say they have lost all of that now to Akwa Ibom and the others to Cameroon, the 13% derivation, can the government on its own say, okay, we'll still be giving you that, even though we know that you no longer produce oil?
That would be a little bit problematic. I think what the situation calls for is for some diplomatic settlement, which I believe Akwa Ibom State is pursuing. I know the governor of Akwa Ibom State, who is a lawyer himself, just like Lile Imoke, they are both lawyers. And lawyers deal in resolving problems. We are social engineers. I think they should enter into serious discussion as to how to cut the losses of, say, Cross River State. I understand he offered 250 million, but that is a drop in the bucket compared with what Cross Rivers used to have. So I think the eminence grace, the wise men of the Republic, should get together and resolve the matter. After all, we've given all manner of consideration to militants who have all sorts of jobs that they now have to restrain their appetite for instability and destabilization. So something should be done, a golden handshake of some sort should be given to Cross River State, so that they won't feel so terribly aggrieved. If you've been used to getting 13% of derivation and now you are high and dry, you know, it's not funny at all. Many of the states that we have to go, like Ekere Madu said. He went to my school in Toronto a few months ago, Deputy president of Senate,
Yeah.
and said that we have baby feeding bottle federalism. That the states have to go to Abuja every month to get money from the federal government. I think the president of the country could provide some succor for an aggrieved Cross River State, to make them a little bit happy, because now they feel frustrated.
Let's go back later now to the Bakassi story. The House of Reps came up recently saying that there was a 10-year window within which, the judgment of the ICJ could actually be reviewed or appealed. And someone is saying that, a respected lawyer, Mr. Femi Falana, says that there is no such thing, or there is no such window.
Actually, as I said at the outset of my intervention on this program, I'm not aware of this 10-year rule. I'm aware that under Article 60 of the Statute of the International Court of Justice, if you have new facts, you can go back for the court to arrive at a new decision. But what new facts are we going to present? So it's an exercise in futility. People just want to raise false hopes, and quite sincerely, we should be sorry. We should be contrite for past, I would say, infelicity of style. We did not do the needful. Femi Falana was talking about the caliber of professors. We have distinguished professors of international law in this country. The only one of significance that was in the team was my friend Tony Chukura. Tony Chukura wrote a PhD in Manchester in 1967 on the settlement of boundary disputes in international law. So somebody like Tony Chukura should have been given the brief.